For more real estate information, please contact Hongyan Jones. Buyer attachment. This attachment should be given to the buyer prior to the submission of any offer and is not part of the residential real estate purchase contract's terms. Attention buyer. You are entering into a legally binding agreement. 1. Read the entire contract before you sign it. 2. Review the residential seller's property disclosure statement. See Section 4A. This information comes directly from the seller. Investigate any blank spaces, unclear answers or any other information that is important to you. 3. Review the inspection paragraph. See Section 6A. If important to you, hire a qualified mold inspector, roof inspector, pest inspector, pool inspector, heating cooling inspector. Verify square footage. See Section 6B. Verify the property is on sewer or septic. See Section 6F. 4. Confirm your ability to obtain insurance and insurability of the property during the inspection period with your insurance agent. See Section 6 and 6E. 5. Apply for your home loan now, if you have not done so already, and provide your lender with all requested information. See Section 2F. It is your responsibility to make sure that you and your lender follow the timeline requirements in Section 2, and that you and your lender deliver the necessary funds to escrow in sufficient time to allow escrow to close on the agreed-upon date. Otherwise, the seller may cancel the contract and you may be liable for damages. 6. Read the title commitment within 5 days of receipt. See Section 3C. 7. Read the CC&Rs and all other governing documents within 5 days of receipt. See Section 3C, especially if the home is in a homeowners association. 8. Conduct a thorough final walkthrough. See Section 6M. If the property is unacceptable, speak up. After the closing may be too late. You can obtain information through the buyer's advisory at http://www.aronline.com. Remember, you are urged to consult with an attorney, inspectors, and experts of your choice in any area of interest or concern in the transaction. Be cautious about verbal representations, advertising claims, and information contained in a listing. Verify anything important to you. Residential resale real estate purchase contract. The pre-printed portion of this form has been drafted by the Arizona Association of Realtors. Any change in the pre-printed language of this form must be made in a prominent manner. No representations are made as to the legal validity, adequacy and/or effects of any provision, including tax consequences thereof. If you desire legal, tax or other professional advice, please consult your attorney, tax advisor or professional consultant. 1. Property. 1A. Buyer, seller, or as identified in Section 9C. Buyer agree to buy and seller agrees to sell the real property with all improvements, fixtures, and appurtenances thereon or incidental thereto, plus the personal property described herein, collectively the premises. 1B. Premises address, assessors. City, county, AZ, zip code. Legal description. 1C $ full purchase price, paid as outlined below. $earnest money. $. 1D. Close of escrow. Close of escrow, COE, shall occur when the deed is recorded at the appropriate county recorder's office. Buyer and seller shall comply with all terms and conditions of this contract, execute and deliver to escrow company all closing documents, and perform all other acts necessary in sufficient time to allow COE to occur on month, day, year, COE date. If escrow company or recorder's office is closed on COE date, COE shall occur on the next day that both are open for business. Buyer shall deliver to escrow company a cashier's check, wired funds or other immediately available funds to pay any down payment, additional deposits or buyer's closing costs, and instruct the lender, if applicable, to deliver immediately available funds to escrow company, in a sufficient amount and in sufficient time to allow COE to occur on COE date. 1e. Possession. Seller shall deliver possession, occupancy, existing keys and/or means to operate all locks, mailbox, security system alarms, and all common area facilities to buyer at COE or broker or brokers recommend that the parties seek appropriate counsel from insurance, legal, tax, and accounting professionals regarding the risks of pre-possession or post-possession of the premises. 1f. Addenda incorporated, as is, additional clause, buyer contingency, domestic water well, HOA, lead-based paint disclosure, loan assumption, on-site wastewater treatment facility, seller financing, short sale. Other. 1g. Fixtures and personal property. Seller agrees that all existing fixtures on the premises, and any existing personal property specified herein, shall be included in this sale, including the following: freestanding range oven, ceiling fans, attached floor coverings, window and door screens, sun screens, garage door openers and controls, outdoor landscaping, fountains, and lighting, pellet, wood burning or gas log stoves, storage sheds, light fixtures, towel, curtain and drapery rods, flush-mounted speakers, storm windows and doors, attached media antennas, satellite dishes, attached fireplace equipment, timers, draperies and other window coverings, shutters and awnings, water misting systems, solar systems, mailbox, central vacuum, hose, and attachments, built-in appliances. If owned by the seller, the following items also are included in this sale: pool and spa equipment, including any mechanical or other cleaning systems, security and/or fire systems and/or alarms, water softeners, water purification systems. Additional existing personal property included in this sale, if checked: refrigerator, washer, dryer, as described. Other. Additional existing personal property included shall not be considered part of the premises and shall be transferred with no monetary value, and free and clear of all liens or encumbrances. Fixtures and leased items not included. If this is an all-cash sale, go to Section 3. 2. Financing. 2a. Pre-qualification. An AAR pre-qualification form is attached hereto and incorporated herein by reference. 2b. Loan contingency. Buyer's obligation to complete the sale is contingent upon buyer obtaining loan approval for the loan described in the AAR Loan Status Update, LSU, from without prior to document, PTD, conditions no later than 3 days prior to the COE date. No later than 3 days prior to the COE date, buyer shall either 1. Sign all loan documents, or 2. Deliver to seller or escrow company notice of loan approval without PTD conditions and date or dates of receipt of closing disclosure or disclosures from lender. Or 3. Deliver to seller or escrow company notice of inability to obtain loan approval without PTD conditions. 2c. Unfulfilled loan contingency. This contract shall be cancelled and buyer shall be entitled to a return of the earnest money if after diligent and good faith effort, buyer is unable to obtain loan approval without PTD conditions no later than 3 days prior to the COE date. Buyer acknowledges that prepaid items paid separately from earnest money are not refundable. 2d. Interest rate necessary funds. Buyer agrees that 1. The inability to obtain loan approval due to the failure to lock the interest rate and points by separate written agreement with the lender. Or 2. The failure to have the down payment or other funds due from buyer necessary to obtain the loan approval without conditions and close this transaction is not an unfulfilled loan contingency. 2e. Loan status update. Buyer shall deliver to seller the LSU with at a minimum lines 140 completed describing the current status of the buyer's proposed loan within 10 days after contract acceptance and instruct lender to provide an updated LSU to broker or brokers and seller upon request. 2f. Loan application. Unless previously completed, Within 3 days after contract acceptance, buyer shall 1. Provide lender with buyer's name, income, social security number, premises address, estimate of value of the premises, and mortgage loan amount sought. And 2. Grant lender permission to access buyer's merged residential credit report. 2G. Loan processing during escrow. Within 10 days after receipt of the loan estimate, buyer shall 1. Provide lender with notice of intent to proceed with the loan transaction in a manner satisfactory to lender. And 2. Provide to lender all requested signed disclosures and the documentation listed in the LSU at lines 32-35. Buyer agrees to diligently work to obtain the loan and will promptly provide the lender with all additional documentation requested. 2H. Type of financing: conventional FHA, VA, USDA, assumption, seller carryback. If financing is to be other than new financing, see attached addendum. 2I. Loan costs: all costs of obtaining the loan shall be paid by the buyer, unless otherwise provided for herein. 2J. Seller concessions, if any, in addition to the other costs seller has agreed to pay herein. Seller agrees to pay up to % of the purchase price or $sign for buyer's loan costs including prepaids, impounds and buyer's title escrow closing costs. 2K. VA loan costs: in the event of a VA loan, seller agrees to pay the escrow fee and up to $sign of loan costs not permitted to be paid by the buyer, in addition to the other costs seller has agreed to pay herein, including seller's concessions. 2L. Changes: buyer shall immediately notify seller of any changes in the loan program, financing terms, or lender described in the pre-qualification form if attached hereto or LSU provided within 10 days after contract acceptance, and shall only make any such changes without the prior written consent of seller if such changes do not adversely affect buyer's ability to obtain loan approval without PTD conditions, increase seller's closing costs, or delay COE. 2M. Appraisal contingency: buyer's obligation to complete the sale is contingent upon an appraisal of the premises acceptable to lender for at least the purchase price. If the premises fails to appraise for the purchase price in any appraisal required by lender, buyer has 5 days after notice of the appraised value to cancel this contract and receive a refund of the earnest money, or the appraisal contingency shall be waived. 2N. Appraisal fees: appraisal fees, when required by lender, shall be paid by buyer, seller, other. Appraisal fees are not included in seller's concessions, if applicable. 3. Title and escrow. 3A. Escrow: this contract shall be used as escrow instructions. The escrow company employed by the parties to carry out the terms of this contract shall be Escrow Title Company. Address: city, state, zip. Email, phone, fax. 3B. Title investing: buyer will take title as determined before COE. Taking title may have significant legal, estate planning and tax consequences. Buyer should obtain legal and tax advice. 3C. Title commitment and title insurance: escrow company is hereby instructed to obtain and deliver to buyer and seller directly, addressed pursuant to 8T and 9C or as otherwise provided, a commitment for title insurance together with complete and legible copies of all documents that will remain as exceptions to buyer's policy of title insurance. Title commitment, including but not limited to conditions, covenants and restrictions, CC and Rs. Deed restrictions and easements. Buyer shall have 5 days after receipt of the title commitment and after receipt of notice of any subsequent exceptions to provide notice to seller of any items disapproved. Seller shall convey title by warranty deed, subject to existing taxes, assessments, covenants, conditions, restrictions, rights of way, easements and all other matters of record. Buyer shall be provided at seller's expense and American Land Title Association, ALTA, homeowner's title insurance policy, or if not available, an ALTA residential title insurance policy, plain language 1-4 units, or, if not available, a standard owner's title insurance policy, showing title vested in buyer. Buyer may acquire extended coverage at buyer's own additional expense. If applicable, buyer shall pay the cost of obtaining the out-to-lender title insurance policy. 3D. Additional instructions. 1. Escrow company shall promptly furnish notice of pending sale that contains the name and address of the buyer to any homeowners association in which the premises is located. 2. If the escrow company is also acting as the title agency but is not the title insurer issuing the title insurance policy, escrow company shall deliver to the buyer and seller, upon deposit of funds, a closing protection letter from the title insurer indemnifying the buyer and seller for any losses due to fraudulent acts or breach of escrow instructions by the escrow company. 3. All documents necessary to close this transaction shall be executed promptly by seller and buyer in the standard form used by escrow company. Escrow company shall modify such documents to the extent necessary to be consistent with this contract. 4. Escrow company fees, unless otherwise stated herein, shall be allocated equally between seller and buyer. 5. Escrow company shall send to all parties and broker or brokers copies of all notices and communications directed to seller, buyer and broker or brokers. 6. Escrow company shall provide broker or brokers access to escrowed materials and information regarding the escrow. 7. If an affidavit of disclosure is provided, escrow company shall record the affidavit at COE. 3E. Tax prorations. Real property taxes payable by the seller shall be prorated to COE based upon the latest tax information available. 3F. Release of earnest money. In the event of a dispute between buyer and seller regarding any earnest money deposited with escrow company, buyer and seller authorize escrow company to release earnest money pursuant to the terms and conditions of this contract in its sole and absolute discretion. Buyer and seller agree to hold harmless and indemnify escrow company against any claim, action or lawsuit of any kind, and from any loss, judgment, or expense, including costs and attorney fees, arising from or relating in any way to the release of earnest money. 3G. Prorations of assessments and fees. All assessments and fees that are not a lien as of the COE, including homeowners association fees, rents, irrigation fees, and, if assumed, insurance premiums, interest on assessments, interest on encumbrances, and service contracts, shall be prorated as of COE or other. 3H. Assessment liens. The amount of any assessment, other than homeowners association assessments, that is a lien as of the COE, shall be paid in full by seller, prorated and assumed by buyer. Any assessment that becomes a lien after COE is the buyer's responsibility. 3I. IRS and FIRPTA reporting. Seller agrees to comply with IRS reporting requirements. If applicable, seller agrees to complete, sign, and deliver to escrow company a certificate indicating whether seller is a foreign person or a non-resident alien pursuant to the Foreign Investment in Real Property Tax Act, FIRPTA. Buyer and seller acknowledge that if the seller is a foreign person, the buyer must withhold a tax equal to 10% of the purchase price, unless an exemption applies. 4. Disclosure. 4A. Seller Property Disclosure Statement, SPDS. Seller shall deliver a completed AAR residential SPDS from to the buyer within 5 days after contract acceptance. Buyer shall provide notice of any SPDS items disapproved within the inspection period or 5 days after receipt of the SPDS, whichever is later. 4B. Insurance claims history. Seller shall deliver to buyer a written 5-year insurance claims history regarding premises, or a claims history for the length of time seller has owned the premises if less than 5 years, from seller's insurance company or an insurance support organization or consumer reporting agency, or if unavailable from these sources, from seller, within 5 days after contract acceptance. Seller may obscure any reference to date of birth or social security number from the document. Buyer shall provide notice of any items disapproved within the inspection period or 5 days after receipt of the claims history, whichever is later. 4C. Lead-based paint disclosure. If the premises were built prior to 1978, the seller shall 1. Notify the buyer of any known lead-based paint, LBP, or LBP hazards in the premises. 2. Provide the buyer with any LBP risk assessments or inspections of the premises in the seller's possession. 3. Provide the buyer with the disclosure of information on lead-based paint and lead-based paint hazards, and any report, records, pamphlets and/or other materials referenced therein, including the pamphlet Protect Your Family from Lead in Your Home, collectively LBP information. Buyer shall return a signed copy of the disclosure of information on lead-based paint and lead-based paint hazards to seller prior to COE. LBP information was provided prior to contract acceptance and buyer acknowledges the opportunity to conduct LBP risk assessments or inspections during inspection period. Seller shall provide LBP information within 5 days after contract acceptance. Buyer may within 10 days or days after receipt of the LBP information conduct or obtain a risk assessment or inspection of the premises for the presence of LBP or LBP hazards. Assessment period. Buyer may within 5 days after receipt of the LBP information or 5 days after expiration of the assessment period cancel this contract. Buyer is further advised to use certified contractors to perform renovation, repair or painting projects that disturb lead-based paint in residential properties built before 1978 and to follow specific work practices to prevent lead contamination. If premises were constructed prior to 1978, buyer's initials required. If premises were constructed in 1978 or later, buyer's initials required. 4D. Affidavit of disclosure, if the premises is located in an unincorporated area of the county, and 5 or fewer parcels of property other than subdivided property are being transferred, the seller shall deliver a completed affidavit of disclosure in the form required by law to the buyer within 5 days after contract acceptance. Buyer shall provide notice of any affidavit of disclosure items disapproved within the inspection period or 5 days after receipt of the affidavit of disclosure, whichever is later. 4E. Changes during escrow. Seller shall immediately notify buyer of any changes in the premises or disclosures made herein, in the SPDS, or otherwise. Such notice shall be considered an update of the SPDS. Unless seller is already obligated by Section 5A or otherwise by this contract or any amendments hereto, to correct or repair the changed item disclosed, buyer shall be allowed 5 days after delivery of such notice to provide notice of disapproval to seller. 5. Warranties. 5A. Seller warranties. Seller warrants and shall maintain and repair the premises so that at the earlier of possession or COE, 1. All heating, cooling, mechanical, plumbing, and electrical systems, including swimming pool and/or spa, motors, filter systems, cleaning systems, and heaters, if any, freestanding range oven, and built-in appliances will be in working condition. 2. All other agreed-upon repairs and corrections will be completed pursuant to Section 6J. 3. The premises, including all additional existing personal property included in the sale, will be in substantially the same condition as on the date of contract acceptance. And 4. All personal property not included in the sale and all debris will be removed from the premises. 5B. Warranties that survive closing. Seller warrants that seller has disclosed to buyer and broker or brokers all material latent defects and any information concerning the premises known to seller, excluding opinions of value, which materially and adversely affect the consideration to be paid by buyer. Prior to the COE, seller warrants that payment in full will have been made for all labor, professional services, materials, machinery, fixtures, or tools furnished within the 150 days immediately preceding the COE in connection with the construction, alteration, or repair of any structure on or improvement to the premises. Seller warrants that the information regarding connection to a sewer system or on-site wastewater treatment facility, conventional septic or alternative, is correct to the best of seller's knowledge. 5C. Buyer warranties. Buyer warrants that buyer has disclosed to seller any information that may materially and adversely affect the buyer's ability to close escrow or complete the obligations of this contract. At the earlier of possession of the premises or COE, buyer warrants to seller that buyer has conducted all desired independent inspections and investigations and accepts the premises. Buyer warrants that buyer is not relying on any verbal representations concerning the premises except disclosed as follows. 6. Due diligence. 6a. Inspection period. Buyer's inspection period shall be 10 days or days after contract acceptance. During the inspection period, buyer, at buyer's expense, shall 1. Conduct all desired physical, environmental, and other types of inspections and investigations to determine the value and condition of the premises. 2. Make inquiries and consult government agencies, lenders, insurance agents, architects, and other appropriate persons and entities concerning the suitability of the premises and the surrounding area. 3. Investigate applicable building, zoning, fire, health, and safety codes to determine any potential hazards, violations or defects in the premises. And 4. Verify in material multiple listing service, MLS, information. If the presence of sex offenders in the vicinity or the occurrence of a disease, natural death, suicide, homicide or other crime on or in the vicinity is a material matter to the buyer, it must be investigated by the buyer during the inspection period. Buyer shall keep the premises free and clear of liens, shall indemnify and hold seller harmless from all liability, claims, demands, damages, and costs, and shall repair all damages arising from the inspections. Buyer shall provide seller and broker or brokers upon receipt, at no cost, copies of all inspection reports concerning the premises obtained by buyer. Buyer is advised to consult the Arizona Department of Real Estate Buyer Advisory provided by AAR to assist in buyer's due diligence inspections and investigations. 6b. Square footage. Buyer is aware that any reference to the square footage of the premises, both the real property, land, and improvements thereon, is approximate. If square footage is a material matter to the buyer, it must be investigated during the inspection period. 6c. Would destroy an organism or insect inspection. If current or past wood destroying organisms or insects, such as termites, are a material matter to the buyer, these issues must be investigated during the inspection period. The buyer shall order and pay for all wood destroying organism or insect inspections performed during the inspection period. If the lender requires an updated wood destroying organism or insect inspection report prior to COE, it will be performed at buyer's expense. 6d. Flood hazard. Flood hazard designations or the cost of flood hazard insurance shall be determined by buyer during the inspection period. If the premises are situated in an area identified as having any special flood hazards by any governmental entity, the lender may require the purchase of flood hazard insurance. Special flood hazards may also affect the ability to encumber or improve the premises. 6e. Insurance. If homeowner's insurance is a material matter to the buyer, buyer shall apply for and obtain written confirmation of the availability and cost of homeowner's insurance for the premises from buyer's insurance company during the inspection period. Buyer understands that any homeowner's, fire, casualty, or other insurance desired by buyer or required by lender should be in place at COE. 6f. Sewer or on-site wastewater treatment system. The premises are connected to a sewer system, septic system, alternative system. If a sewer connection is a material matter to the buyer, it must be investigated during the inspection period. If the premises are served by a septic or alternative system, the AAR on-site wastewater treatment facility addendum is incorporated herein by reference. Buyer's initials required. 6g. Swimming pool barrier regulations. During the inspection period, buyer agrees to investigate all applicable state, county, and municipal swimming pool barrier regulations and agrees to comply with and pay all costs of compliance with said regulations prior to occupying the premises, unless otherwise agreed in writing. If the premises contains a swimming pool, buyer acknowledges receipt of the Arizona Department of Health Services approved private pool safety notice. Buyer's initials required. 6h. Buyer acknowledgement. Buyer recognizes, acknowledges, and agrees that broker or brokers are not qualified, nor licensed, to conduct due diligence with respect to the premises or the surrounding area. Buyer is instructed to consult with qualified licensed professionals to assist in buyer's due diligence efforts. Because conducting due diligence with respect to the premises and the surrounding area is beyond the scope of the broker's expertise and licensing, buyer expressly releases and holds harmless broker or brokers from liability for any defects or conditions that could have been discovered by inspection or investigation. Buyer's initials required. 6I. Inspection period notice. Prior to expiration of the inspection period, buyer shall deliver to seller a signed notice of any items disapproved. AAR's buyer's inspection notice and seller's response form is available for this purpose. Buyer shall conduct all desired inspections and investigations prior to delivering such notice to seller, and all inspection period items disapproved shall be provided in a single notice. 6J. Buyer disapproval. If buyer, in buyer's sole discretion, disapproves of items allowed herein, buyer shall deliver to seller notice of the items disapproved and state in the notice that buyer elects to either 1. Immediately cancel this contract and all earnest money shall be released to buyer, or 2. Provide the seller an opportunity to correct the items disapproved, in which case A. Seller shall respond in writing within 5 days or days after delivery to seller of buyer's notice of items disapproved. Seller's failure to respond to buyer in writing within the specified time period shall conclusively be deemed seller's refusal to correct any of the items disapproved. B. If seller agrees in writing to correct items disapproved, seller shall correct the items, complete any repairs in a workmanlike manner and deliver any paid receipts evidencing the corrections and repairs to buyer 3 days or days prior to COE date. C. If seller is unwilling or unable to correct any of the items disapproved, buyer may cancel this contract within 5 days after delivery of seller's response or after expiration of the time for seller's response, whichever occurs first, and all earnest money shall be released to buyer. If buyer does not cancel this contract within the 5 days as provided, buyer shall close escrow without correction of those items that seller has not agreed in writing to correct. Verbal discussions will not extend these time periods. Only a written agreement signed by both parties will extend response times or cancellation rights. Buyer's failure to give notice of disapproval of items or cancellation of this contract within the specified time period shall conclusively be deemed buyer's election to proceed with the transaction without correction of any disapproved items. 6K. Notice of non-working warranted items. Buyer shall provide seller with notice of any non-working warranted items of which buyer becomes aware during the inspection period, or the seller warranty for that item shall be waived. Delivery of such notice shall not affect seller's obligation to maintain or repair the warranted items. 6L. Home Warranty Plan. Buyer and seller are advised to investigate the various home warranty plans available for purchase. The parties acknowledge that different home warranty plans have different coverage options, exclusions, limitations, service fees, and most plans exclude pre-existing conditions. A home warranty plan will be ordered by buyer or seller with the following optional coverage. To be issued by at a cost not to exceed $, to be paid for by buyer seller. Buyer declines the purchase of a home warranty plan. 6M. Walkthroughs. Seller grants buyer and buyer's inspector or inspectors reasonable access to conduct walkthroughs of the premises for the purpose of satisfying buyer that any corrections or repairs agreed to by the seller have been completed, warranted items are in working condition, and that the premises is in substantially the same condition as of the date of contract acceptance. If buyer does not conduct such walkthroughs, buyer releases seller and broker or brokers from liability for any defects that could have been discovered. 6N. Seller's responsibility regarding inspections and walkthroughs. Seller shall make the premises available for all inspections and walkthroughs upon reasonable notice by buyer. Seller shall, at seller's expense, have all utilities on, including any propane, until COE to enable buyer to conduct these inspections and walkthroughs. 7. Remedies. 7A. Cure period. a party shall have an opportunity to cure a potential breach of this contract. If a party fails to comply with any provision of this contract, the other party shall deliver a notice to the non-complying party specifying the non-compliance. If the non-compliance is not cured within 3 days after delivery of such notice, cure period, the failure to comply shall become a breach of contract. 7b. Breach. In the event of a breach of contract, the non-breaching party may cancel this contract and/or proceed against the breaching party in any claim or remedy that the non-breaching party may have in law or equity, subject to the alternative dispute resolution obligations set forth herein. In the case of the seller, because it would be difficult to fix actual damages in the event of buyer's breach, the earnest money may be deemed a reasonable estimate of damages and seller may, at seller's option, accept the earnest money as seller's sole right to damages. And in the event of buyer's breach arising from buyer's failure to deliver the notice required by Section 2B, or buyer's inability to obtain loan approval due to waiver of the appraisal contingency pursuant to Section 2M, seller shall exercise this option and accept the earnest money as seller's sole right to damages. An unfulfilled contingency is not a breach of contract. The parties expressly agree that the failure of any party to comply with the terms and conditions of Section 1D to allow COE to occur on the COE date, if not cured after a cure notice is delivered pursuant to Section 7A, will constitute a material breach of this contract, rendering the contract subject to cancellation. 7C. Alternative Dispute Resolution, ADR. Buyer and seller agree to mediate any dispute or claim arising out of or relating to this contract in accordance with the Realtor's dispute resolution system, or as otherwise agreed. All mediation costs shall be paid equally by the parties. In the event that mediation does not resolve all disputes or claims, the unresolved disputes or claims shall be submitted for binding arbitration. In such event, the parties shall agree upon an arbitrator and cooperate in the scheduling of an arbitration hearing. If the parties are unable to agree on an arbitrator, the dispute shall be submitted to the American Arbitration Association, AAA, in accordance with the AAA arbitration rules for the real estate industry. The decision of the arbitrator shall be final and non-appealable. Judgment on the award rendered by the arbitrator may be entered in any court of competent jurisdiction notwithstanding the foregoing. Either party may opt out of binding arbitration within 30 days after the conclusion of the mediation conference by notice to the other, and in such event either party shall have the right to resort to court action. 7D. Exclusions from ADR. The following matters are excluded from the requirement for ADR hereunder. 1. Any action brought in the Small Claims Division of an Arizona Justice Court, up to $3,500, so long as the matter is not thereafter transferred or removed from the Small Claims Division. 2. Judicial or non-judicial foreclosure or other action or proceeding to enforce a deed of trust, mortgage, or agreement for sale. 3. An unlawful entry or detainer action. 4. The filing or enforcement of a mechanic's lien. Or, 5. Any matter that is within the jurisdiction of a probate court. Further, the filing of a judicial action to enable the recording of a notice of pending action, lis pendens, or order of attachment, receivership, injunction, or other provisional remedies shall not constitute a waiver of the obligation to submit the claim to ADR, nor shall such action constitute a breach of the duty to mediate or arbitrate. 7E. Attorney fees and costs. The prevailing party in any dispute or claim between buyer and seller arising out of or relating to this contract shall be awarded their reasonable attorney fees and costs. Costs shall include, without limitation, attorney fees, expert witness fees, fees paid to investigators, and arbitration costs. 8. Additional terms and conditions. 8A. 8B. Risk of loss. If there is any loss or damage to the premises between the date of contract acceptance and COE or possession, whichever is earlier, by reason of fire, vandalism, flood, earthquake, or act of God, the risk of loss shall be on the seller, provided, however, that if the cost of repairing such loss or damage would exceed 10% of the purchase price, either seller or buyer may elect to cancel the contract. 8c. Permission. Buyer and seller grant broker permission to advise the public of this contract. 8d. Arizona law. This contract shall be governed by Arizona law and jurisdiction is exclusively conferred on the state of Arizona. 8e. Time is of the essence. The parties acknowledge that time is of the essence in the performance of the obligations described herein. 8f. Compensation. Seller and buyer acknowledge that broker or brokers shall be compensated for services rendered as previously agreed by separate written agreements, which shall be delivered by broker or brokers to escrow company for payment at COE, if not previously paid. If seller is obligated to pay broker or brokers, this contract shall constitute an irrevocable assignment of seller's proceeds at COE. If buyer is obligated to pay broker or brokers, payment shall be collected from buyer as a condition of COE. Commissions payable for the sale, leasing, or management of property are not set by any board or association of realtors, or multiple listing service, or in any manner other than between the broker and client. H.E. Copies and counterparts. A fully executed facsimile or electronic copy of the contract shall be treated as an original contract. This contract and any other documents required by this contract may be executed by facsimile or other electronic means and in any number of counterparts, which shall become effective upon delivery as provided for herein, except that the lead-based paint disclosure statement may not be signed in counterpart. All counterparts shall be deemed to constitute one instrument, and each counterpart shall be deemed an original. 8h. Days. All references to days in this contract shall be construed as calendar days, and a day shall begin at 12 a.m. and end at 11:59 p.m. 8i. Calculating time periods. In computing any time period prescribed or allowed by this contract, the day of the act or event from which the time period begins to run is not included and the last day of the time period is included. Contract acceptance occurs on the date that the signed contract, and any incorporated counter-offer, is delivered and received by the appropriate broker. Acts that must be performed 3 days prior to the COE date must be performed 3 full days prior, that is, if COE date is Friday, the act must be performed by 11:59 p.m. on Monday. 8j. Entire agreement. This contract, and any addenda and attachments, shall constitute the entire agreement between seller and buyer, shall supersede any other written or oral agreements between seller and buyer and can be modified only by a writing signed by seller and buyer. The failure to initial any page of this contract shall not affect the validity or terms of this contract. 8k. Subsequent offers. Buyer acknowledges that seller has the right to accept subsequent offers until COE. Seller understands that any subsequent offer accepted by the seller must be a backup offer contingent on the cancellation of this contract. 8l. Cancellation. A party who wishes to exercise the right of cancellation as allowed herein may cancel this contract by delivering notice stating the reason for cancellation to the other party or to the escrow company. Cancellation shall become effective immediately upon delivery of the cancellation notice. 8m. Notice, unless otherwise provided, delivery of all notices and documentation required or permitted hereunder shall be in writing and deemed delivered and received when 1. Hand-delivered. 2. Sent via facsimile transmission. 3. Sent via electronic mail, if email addresses are provided herein. Or 4. Sent by recognized overnight courier service, and addressed to buyer as indicated in Section 8R, to seller as indicated in Section 9 and to the escrow company indicated in Section 3A. 8n. Earnest money. Earnest money is in the form of personal check other. If applicable, earnest money has been received by broker named in Section 8R and upon acceptance of this offer will be deposited with escrow company broker's trust account. Buyer acknowledges that failure to pay the required closing funds by the scheduled close of escrow, if not cured after a cure notice is delivered pursuant to Section 7A, shall be construed as a material breach of this contract, and all earnest money shall be subject to forfeiture. 8.0. Release of broker or brokers. Seller and buyer hereby expressly release, hold harmless and indemnify broker or brokers in this transaction from any and all liability and responsibility regarding financing, the condition, square footage, lot lines, boundaries, value, rent rolls, environmental problems, sanitation systems, roof, wood infestation, building codes, governmental regulations, insurance, price and terms of sale, return on investment, or any other matter relating to the value or condition of the premises. The parties understand and agree that the broker or brokers do not provide advice on property as an investment and are not qualified to provide financial, legal, or tax advice regarding this real estate transaction. Seller's initials required, buyer's initials required. 8p. Terms of acceptance. This offer will become a binding contract when acceptance is signed by seller and a signed copy delivered in person, by mail, facsimile or electronically, and received by broker named in Section 8R by, at, a.m. p.m., Mountain Standard Time. Buyer may withdraw this offer at any time prior to receipt of seller's signed acceptance. If no signed acceptance is received by this date and time, this offer shall be deemed withdrawn and the buyer's earnest money shall be returned. 8q. This contract contains 9 pages exclusive of any addenda and attachments. Please ensure that you have received and read all 9 pages of this offer as well as any addenda and attachments. 8r. Broker on behalf of buyer. Print salesperson's name, agent MLS code, agent state license number. Print firm name, firm MLS code. Firm address, state, zip code, firm state license number. Preferred telephone, fax, email. 8s. Agency confirmation. The broker named in Section 8R above is the agent of, check 1. The buyer, the seller, or both the buyer and seller. 8t. The undersigned agreed to purchase the premises on the terms and conditions herein stated and acknowledge receipt of a copy hereof including the buyer attachment. Buyer's signature, month, day, year. Address, city, state, zip code. 9. Seller acceptance. 9a. Broker on behalf of seller. Print salesperson's name, agent MLS code, agent state license number. Print firm name, firm MLS code. Firm address, state, zip code, firm state license number. Preferred telephone, fax, email. 9b. Agency confirmation. The broker named in Section 9a above is the agent of, check 1. The seller, or both the buyer and seller. 9c. The undersigned agreed to sell the premises on the terms and conditions herein stated, acknowledge receipt of a copy hereof and grant permission to broker named on Section 9a to deliver a copy to buyer. Counter offer is attached, and is incorporated herein by reference. Seller should sign both this offer and the counter offer. If there is a conflict between this offer and the counter offer, the provisions of the counter offer shall be controlling. Seller's signature, month, day, year. Seller's name printed. Address, city, state, zip code. Offer rejected by seller, month, day, year. Seller's initials. Residential resale real estate purchase contract updated, September 2015.